could if there are representatives from Cameron County on, could you please confirm that you're on and identify yourselves, please?
Yes, sir. We're here. My name is Edwin Tompkins. I'm the Cameron County Solicitor. With me is Commissioner Jessica Herzing, Commissioner Joshua Zuckel, Commissioner James Moat, our Chief Probation Officer, Stephen Fingato, and our Children and Youth Services Director, Shirley Wolf. Also present is the Cameron County Chief Clerk, Annette Campbell.
Good. Thank you very much. Appreciate it. Could you please call the roll of the trustees, Brianna?
Yes. Tamar Alexander,
Present.
Commissioner Kevin Boozle,
Present.
Aaron Dalton,
Yes, I'm here. I'm sorry to be homesick and off camera, but I'm here.
Shay Madden,
Here.
Commissioner Robert Postal,
Here.
Senator Christine Tartaglione,
Present.
Chair Tom Van Kirk.
Here. Okay, we have the entire dispute resolution committee present. I'd like to make a couple of announcements before we start. The meeting of the Pennsylvania Opioid Trust Dispute Resolution Committee has been duly advertised as a public meeting in accordance with the Sunshine Act and is therefore open to the members of the public as observers. Participation in the meeting is limited, in this case, to Cameron County as a beneficiary under the trust order and its designated representatives, trustees on the DRC, and those that the trustees have invited in advance to take part. This meeting is being recorded and minutes from the meeting will be available on the trust website after they are approved. I would note that an executive session was held immediately prior to this public meeting for the purpose of receiving legal updates and legal advice. With that, we can move on with the agenda. There were minutes of the meeting of the DRC that was conducted on October the 29th, 2024. Could I have a motion to approve those minutes, please?
I'll do a motion.
Second?
Second.
Okay, any discussion? All those in favor, please say aye.
Aye.
Opposed? Thank you. The instant appeal has brought up one question concerning our operating procedure. We had intended that all appeals would have to be taken within 30 days of the time that the group that was making the appeal knew or should have been aware of the decision of the entire trust. In this case, the decision of on Cameron County's various programs were made on in the August meeting, and obviously the time frame within which they filed their appeal, which I believe was at the end of October, actually beginning of November, was more than the 30 days passed. I did decide and looked at it and thought that fairness would dictate, because the operating procedures might not have been as clear as they could have been, that we ought to allow the appeal. But I do want to make sure that going forward, the appeals are on a more timely basis. So for that reason, I asked council to draft a resolution which would amend the operating procedures. The purpose of the amendment is to make clear that any appeal to the dispute resolution committee must be filed within 30 days of when the beneficiary knew or should have known of the basis for appeal. And there might be certain exceptions to that deadline, provided the appeal is filed within a reasonable period of time, but it will be the DRC that will have the sole discretion to determine what constitutes a reasonable period of time under the circumstances. So going forward, I would urge any beneficiary that disagrees with a decision of the trust that they make their appeal within 30 days. As I said, it would not affect this would not affect this appeal. So therefore, I would ask for a resolution that resolved that the Dispute Resolution Committee of the Pennsylvania Opioid Trust hereby amends its operating procedures consistent with those circulated to members of the DRC in advance of the meeting. The amended operating procedures would become effective and will be posted on the trust website. Can I have a motion to that effect, please?
So moved, Kevin Boozle.
Thank you, Kevin. Second?
I'll second Shay Madden.
Thank you, Shay. Any discussion? All those in favor, please say aye.
Aye.
Opposed? Okay. Thank you very much. We will now move on to the main purpose of the meeting, which is the appeal of Cameron County concerning its program number 2, Government Agency Assistance Services. Edward, I assume you will be the primary spokesman for the group?
Yes, sir.
Okay, if I could ask one question to begin. Am I correct that there were various programs initially that were submitted in March when we had our initial reporting period? There were 3 different programs that were being set forth at that time, all of which we deemed to be non-compliant eventually. Am I correct that this appeal relates solely to the program number 2, which was labeled shorthand Governmental Agency Assistance Services?
That's correct.
Okay. And could you also confirm what is the amount of dollars that are involved in this appeal? We had some discussion as to whether it's 22.8 or whether or not it is more, it is 45.6.
$22,842.
Okay, thank you. And do you know of that percentage, what was spent for the probation office wages and what was spent on the community and youth services?
Yes, sir, I do. I didn't know the procedure here. I'm used to courtroom procedure. Obviously, this is a little bit more informal. We do have all that information, and in fact, that was put together originally in a spreadsheet and sent in response to an inquiry by the board.
Okay.
Unfortunately, somehow it didn't get to you folks, even though it was sent back in June. And when you met in August 22nd, the trustees board met, it was like Cameron County did not respond, and therefore it's disapproved.
Okay.
Since that time, having gone through the entire record of this appeal, it was discovered that certain information that was sent back in June is not part of the record. The record has since been supplemented, and you now have that in front of you, including that spreadsheet. I was going to have our Commissioner Herzing explain those percentages. If you'd like me to do that now, I can do that. Otherwise, I was just going to give a quick opening statement.
Okay, I'll tell you what, we do eventually want that information, but I don't want to deprive you of the courtroom procedures that I'm used to also, but I never fancied myself as much of a judge, Edward. So why don't you go ahead and make your introductory statement?
Okay, thank you very much. First of all, we appreciate the committee and your recognition that the procedures for an appeal weren't crystal clear. Henceforth, they will be, and we certainly will educate ourselves on that. So thank you. What I wanted to state, and as you would know, Mr. Chairperson, a lot of times you can ask for judicial notice in a court of law. Well, one of the things that we think it's important that this dispute resolution committee understand is who they're dealing with. Who is Cameron County? A lot of you are probably used to much larger counties. The state officially has designated Cameron County as the poorest county in the state of Pennsylvania out of 67 counties. We have a poverty rate of 15.3%. And with a population in our 8th class county from 2023 of 4,380 people, we have to get creative. We are not a county of means or resources. That being said, we intend to address the August 22nd, 2024 decision of the Opioid Trust Board when they did say that the augmentation of salaries to hire and retain our Cameron County Children and Youth Service workers and our probation workers, which we presented as opioid remediation, was non-compliant with the settlement terms in Exhibit E because we failed to provide certain information. That being said, in just one moment, we will address that. I just want to, for the record, point out that on June 12th, 2024, Commissioner Herzing, having put together a spreadsheet, etc., in response, did send that information to her contact at the Opioid Trust Board, but for whatever reason, we do not know, it never became part of the record of the board for their consideration at their August 22nd meeting.
And if that was an error on our part, we apologize. I don't know what could have happened to it. Sometimes emails just don't go through, but so
Sometimes.
we are not intending to hold that against either you or us at this time. I will say, and I just got a note from Bree Anderson, we must have received it because it was looked at by the working group. So we did get the information, and it was part of our consideration of the working group that ultimately made the recommendation to the board. But one way or the other, this committee also has it in front of them because we circulated exactly what Jessica resent to us.
Thank you. Several things in that record that I'm sure all committee members are aware, but originally October 5, 2022, in response to an inquiry that date of then County Commissioners Lori Reed and Ann Losey, Deputy Attorney General David Wade specifically did note, when asked about augmenting the funds for children and youth and probation caseworkers to assure training and retention, Mr. Wade opined at that time, quote, as this type of use is clearly approved according to Exhibit E, and he cites E10, that planned expenditure seems fine to me. That is what the commissioners and the county then relied upon at the time.
Edward, if I could, just so the record is totally clear, I would say that you only read a portion of his response.
That is correct.
The next sentence also goes on to say this does not constitute official guidance from the trust.
It doesn't, but it also says in parentheses, with all due respect, that although that's not required, I believe that email. So the language does stand for exactly that. We also reviewed at that time Exhibit E. And again, if we look at pages E8 under D, addressing the needs of criminal justice, this is all under Schedule B approved uses, and pages E9 and 10, addressing families, that would be a subsection E, it appeared to us that yes, it would work. I understand the trustee board's concern, and perhaps this committee's concern, that these were being used not to rehabilitate, not to remediate, or augment services to opioid users and their families, but they were going to use to supplement the court proceeding. And today, and they can verify this, our chief probation officer, Mr. Dago, our director of children and youth, Shirley Wolf, would like this committee to understand that Cameron County relies on these folks. They are our social workers. We do not have in-treatment facilities in Cameron County. We have no other social workers out there that can help in this particular system. Children and youth, let's look at that for just a second. Children and youth doesn't just, those of you that are familiar with the system, wait for court cases and then take dependency petitions or take children away. That would be contrary to prevailing law. To the contrary, children and youth is there and has a myriad of open cases where they receive a referral, and sometimes the family themselves come to them. And we want to keep those children safe in the home. And children and youth provides counseling services, referral services. They go to the house and help. They provide all kind of extra supplemental household goods. And most importantly, they provide transportation to counseling services, medical appointments. Cameron County also, several years ago, through our district attorney, participated in the LEDI program through the AG's office. What that is designed to do is to avoid people clogging up the criminal justice system. So our probation office constantly has cases and referrals that are not formal court supervision, just like children and youth, not formal. They provide an ear, a recommendation, transportation. That's all we have here in Cameron County to provide those services. So we do believe that if we look at in light of Cameron County's unique and resilient because of our income, the paucity of income that we have in Cameron County, we are complying with the spirit of Exhibit E in using those funds during 2023. In essence, I know what this committee may be thinking. Well, then why don't you just hire a new caseworker using those funds? Well, as I sit in this courthouse today, and this will be verified by Commissioner Herzing, we don't have any room. We can't have a special caseworker that's going to handle this, move in with children and youth. That won't work because of confidentiality laws and lack of space. That won't work with probation. That is a court-generated and supervised program, and that won't work with confidentiality. There is not one office in this courthouse, nor in downtown Emporium, Pennsylvania, that could be set up as a separate caseworker. more importantly, these people already have been trained as their caseworkers. They are our frontline workers. They're the people that have the contact to help these people so they don't go to jail, to help them with rehabilitation, to keep families together. To suddenly create a new position, it would be a logistical nightmare and not sustainable. It would not work. It would be duplicating efforts. These people do one, excuse my language, hell of a job for the resources they have. So with that background, now that you have the exhibits, I would like Commissioner Herzing just to explain the spreadsheet she put in there about the expenditures, if I may. Jessica, would you please explain then the spreadsheets that you forwarded as a response to the inquiry and what amount of funds we're talking about, the percentage that was actually used to augment salaries of children and youth workers and probation workers so that can retain good people?
Sure. So I had responded in the inquiries about how the money was spent to clarify the amounts. And I outlined each of the different programs and what the total program wages tied to it were and what portion of it was supplied from the county's general fund versus the opioid fund allotment that was given to each of the programs. I then included a column of percent opioid funding of total expense, which outlines what percentage of the total program's expense was covered by the opioid fund allotment. And then I included a percentage of positions tied to the exhibit. Excel doesn't give you a lot of space. So percentage of positions tied was a percentage of the time the positions allocated to opioid programming, like Exhibit E programming. And so then the final column is the percentage of opioid funding greater than the percentage of time the position would be tied to Exhibit E, which in all cases was yes. As you can see from the percentage of opioid funding of the total expense of each of these programs for probation and CYS, it is much lower than the amount of wages actually tied to those departments serving OUD cases in their case portfolios. And so from our point of view, like I said in that email, was in justifying whether this expense was of the proper utilization of Exhibit E usage to the amount of what the money was spent was we are well below total cost for OUD that opioid fund is covering. The actual amount of probation, to answer your first question, was probation wages that were covered by the opioid fund was $13,893.30, and CYS was $8,949.
Okay, thank you.
You're welcome.
And could I ask a question about the, first of all, Kevin, did you have a question? Was your hand up?
I did, but go ahead, Tom. I'll wait for yours. Go ahead.
Go ahead, please.
Commissioner Kevin Boozle, my heart and gratitude goes out to the commissioners because I know what it's like to try to do that type of work. And we oftentimes call them unfunded mandates, which we're all used to. I do want to say that each of those departments are supplemented by state funds. CYS definitely is, and probation. And so I'm speaking my own mind and not the trust. These are things that we have sort of deliberated as well. And with that being said, I think that the difference, and I think the attorney had mentioned it, there is a reason you can't just put a generalized caseworker in probation or in CYS because they are different. And the difference is one is authoritative and the other is not. One has the ability to take the children, or in probation's case, detain, And this caseworker and our prevention and treatment is obviously different. Now, I'm not saying that COAS doesn't provide those services, and I'm not saying probation doesn't provide those services. My question would be, do you not contract a service provider for outpatient services, whether it be parenting classes or any type of service that in your community? And I understand you have a restricted number of those, but can you say that you don't have any of those services contracted through either of those departments? You don't have access to any programs? And I just need that clarified. Thank you.
No, sir, we do have access and I will allow our respective directors and chief probation officer to address that. The problem is that those services are not always readily available. So I appreciate your recognition, but unlike many other probation departments in a larger area that can afford it, our probation officers and our children and youth officers, the last thing they want to do under the law is exercise their authority. Granted, when it's a court-ordered situation, they have to, but our respective departments act under the premise of preventative law. They don't want to see somebody arrested for a violation. They don't want to see families torn apart. And they are the frontline workers.
Well, sir, I'd hopefully say that that would be the case in all counties. Certainly, that should definitely be the case.
So with that, Shirley, if you would like to explain some of the services that can be provided, but what your agency actually does.
Yes, we do coordinate some services with providers, and we can make those referrals out, or depending on what they are, we can contract for those services. However, we are an intricate piece of that, you know, to ensure that they comply, you know, and they're all voluntary, obviously, unless they're court ordered, to ensure that they are, you know, doing what they need to do. If they need transportation to and from these services, we also provide that. You know, we are there to assist these families in any way possible with whatever services needed, regardless.
Now, there are parenting classes, correct?
That would be correct. Yes, it's limited though. We do not have a specific class for our county, which means that we have to reach out to surrounding counties. Now, their county citizens, or, you know, people that are in their county, get first dibs on that. So, you know, we would have to wait or, you know, try to provide another service in the interim until we can get them into those programs. And we do have to pay for them.
And you also, we have a drug and alcohol services in town.
That would be correct. Yes.
But what's the limitations on their services?
They are, aside from that, we wouldn't contract with them, you know, they would be referred out to this particular service, and, you know, then we would have to get releases in order to make communication and coordinate any services and to monitor how that is going, you know, so that we can be there to help these families in any way possible to let them know that this is an important thing to have happen so that we can maintain a family unity.
And that's required by law.
Yeah. Correct, yes, yes. Family First Act is in place, of course, so that we are not just farming out into foster care or group homes. They want to make sure that we are trying to get our case management services or services that are needed in the unit to maintain that family unity as best as possible, as safe as possible.
Could I ask one question in that regard? You mentioned farming out to another county, I believe, and that you have to pay for it in addition to waiting for their availability, but you have to pay for it. can I assume you use opioid funds, which by the way, in my view would be permissible, to pay the other county for the work that they're providing to you?
I don't believe that we're utilizing those funds for that purpose. It would come out of a different funding for that particular service.
If
That
it's
would-
for opioid, you might want to consider that.
Right. Okay, well, that's good to know.
If we encourage the counties to work together as much as they can, particularly smaller counties that might not be getting all that much, that it might be more beneficial to have 2 or 3 counties working toward a common goal than to just have each county out there separately. So that's why I made the comment I did. So if you turn to other counties to provide services that are opioid related and have to pay for it, I would encourage you to consider using opioid funds for it, okay?
Thank you.
That still raises the question of transportation, which becomes when children and youth is involved or probation, they do the transportation. Our closest county would be Elk County, and the closest area would be St. Mary's, Pennsylvania, 20 miles away. Likewise, above us is McKean County. That would entail going to Bradford, approximately 50 miles away, 55 miles away. And Potter County, which would be Coudersport, Pennsylvania, which would be approximately 28 to 30 miles away for.
Right.
So
So we have provided, when counties have requested monies and use of opioid funds for transportation purposes, so that people that are afflicted with opioid need transportation and need travel money in order to get to other places, that we have viewed as an authorized expense.
certainly, that brings up another question. Part of the reason that this came about was the agency's problem in retaining caseworkers. Is that correct?
That is correct. Yes.
Okay. Prior to being able to use some of these funds to augment the salaries and make them competitive with salaries in neighboring counties, what was your turnover? I mean, could you describe your turnover?
It seemed like we were just a training ground because they would come in and then they would leave. We were lucky to keep them 6 months.
Yeah, we did see the documents that related to that. We saw the tremendous amount of turnover, and we know that's what led you to ask your initial question of the Attorney General. Could we ask the probation officer? And I just have one question I want to ask. If somebody is violating the terms of their probation, whether they're a child, whether they're an adult, if they had been convicted or given probation for a opioid offense, and if they violate that probation, do you recommend them being incarcerated?
Mr. Chairman, I can say in the last 5 years, our philosophy has changed and the rules of criminal court procedure and probation procedure have changed. And that every situation is different and every situation is fluid. However, I would say that no, as a matter of fact, every time that we have to bring them before the court for a revocation procedure, we are always asking for treatment as a component to their resentence. As a matter of fact, regardless if we bring them before the court for a revocation procedure, we're always going to be using treatment as a alternative to incarceration. As a matter of fact, we have individuals who are violating their probation, and in lieu of receiving incarceration, we give them the opportunity to, if you go to treatment and we'll help you get there, we will essentially keep you out of having to go before the court. And that's a philosophy that we've been doing for many years now.
Thank you.
If I might supplement that, Cameron County does not have its own jail facility. Cameron County has to contract out with neighboring counties for jail services. Therefore, that has been a prevailing philosophy and attitude with our Court of Common Pleas judge and our district attorney, let alone the probation department. It's a last resort.
Right, and if I may, touch upon a comment that Commissioner Boozle had stated earlier about how our departments our funding is partially funded through government funds and whatnot, that within the next 5 fiscal years, PCCD is cutting our funds by approximately 60% in regards to the Act 115 of 2019 with the new funding formulas through PCCD and how they changed around what we call our old grant and aid formula. So between this year and into fiscal year 2029, our government funding is taking a massive cut.
Okay, thank you. We are coming near the end, but I do want to make sure that all the trustees get their questions answered. So other trustee, Rob, I see you
Yeah,
happen to be on my screen, so I saw you were raising your hand. If somebody else was first, I apologize, but would you go ahead?
Yeah, I'm sorry, I couldn't find my little app here to raise my hand. I would like to return to the rationale of salary augmentation, I guess it was said, because when I read what Cameron County had submitted, historically, these offices weren't compensated fairly or equitably for the additional requirements the opioid epidemic has caused their offices. And I think somewhere there is a table, I know that I've seen the table for base salaries and then the new starting salary. I think you know what I'm referring to. And I guess my reaction was, well, this is just the way to give people raises, if you want to be very frank about it. As a commissioner, I know what our CYS retention and problems of recruitment. You all know that. I don't think Cameron's any different than a lot of counties, including Mifflin. I have a lot of vacancies in my CYS. Probation, not so much. But so my reaction to that, people, was, well, this is being used for raises. It would almost be easier for me to justify, particularly in CYS, but maybe in probation, that the existing salaries would be not supplemented, but I'm going to say some of it supplanted because of the additional opioid cases that you are experiencing. So instead of the augmentation, which to me, and please address this again, seems to be, well, this is a raise to get your salaries closer to what maybe the market is in other counties. And I'm not so sure that's the purpose of the settlement, is to maintain the market wages in Cameron County.
I understand that. And as the new commissioner that was tasked with taking on the opioid fund reporting from when Lori and Ann left, I spent a lot of time reading through the minutes of our salary board and going through their folders to understand exactly how they were thinking about this, so I could try to explain it in the reporting. And I think that if their goal and intention was to just create an increase on the wages, then that would have been what they would have outlined it as, instead of going back through and making this a standard amount year over year of base wage portion to cover the fact that unfortunately our county sees a systemic need for continuing all of these extra services that are being provided by our COS and probation offices. I understand your comments too about, well, we funded things for rideshare and we funded things for that. I think it's important for you to be aware, those nonprofits don't exist here. We can't fund that because no such program exists. All of the people that we contract with to provide these services are in the counties that surround us. Dickinson Mental Health, Elk County. Potter County Women's Recovery Center, Potter County. A lot of your training services and stuff come out of McKean County. We're part of large regional things, but nothing serves us independently. ADAS is based in Potter County. We're slowly getting to have a on-site rehabilitation system here because they're working on that, but it's not open yet. So yes, you have funded those things. None of those things exist here. Unfortunately, this is what exists here.
Understood.
And they're doing an excellent job of meeting those shortfallings and making sure that the people here are getting the help that they need, because when they encounter a shortfall, they make up the difference.
Understood. And by the way, I really appreciate the presentations by both Child and Youth Services and probation, as well as yourself, Jessica. I think you guys are doing an excellent job. And I do understand that Cameron is different than a lot of other counties. So I recognize that. Any other trustees?
Tom, it's
Oh.
Shay. I had a
Yeah,
quick
Shay.
quick
Thank you,
quick
Shay.
question. So I did hear you mention your county drug and alcohol agency. Could you talk about your relationship with them? Because they do have a satellite in Emporium, correct?
They do. And it's been in existence for a couple of years now. I would say at least a few years.
Probably, I would say.
When they put in their local one here. Yes,
They've been here for several years before I was even here.
right. And I will say too, that ADAS had not put in any requests up until last year for any type of fund usage from our opioid fund, up until last year's recovery request in 2014.
24.
Yeah, sorry, 2024.
24. Okay.
Too many numbers, but
I mean, has there been any, conversation with them, sitting down with them to have them maybe implement some of the programs that you're looking at? And I guess a follow-up to that also is, do you not have a MATP program in your county? Medicaid transportation?
Yeah. Well, it's through a county assistance office. If they're on, if they're involved with our county welfare office and say they have a, county card, a medical card that they can utilize, that piece if they, need to do that.
If they have one. right?
If they have,
If they have one.
yeah, if they have one.
I would always encourage you to have all your folks apply, because I listened to your opening remarks about the poverty level and such. And so I'm imagining a good portion of your folks would be eligible for Medicaid.
A lot of it
What-
is, even if they were approved, the transportation system, we have an ATA bus service that will take people to nearby Elk County. But as far as going to Potter County, McKean County, it doesn't exist.
and our ATA service doesn't take care of multiple appointments on a single ride. So you have to go to one appointment and come back. They won't do multiple appointments across town.
Just another quick question. This is Commissioner Postal. I guess this goes to the commissioners. And when you were explaining the percentage of opioid funding to probation, 7.8%, CYS 2.9%, is that pretty constant? Is that what you have in the budget for 2025? For example?
We didn't include this in the budget for 2025 because we weren't sure how this appeal would fall out. When I put in our information return, I listed that our future use of these programs and what they might do was unsure because we weren't sure what this would entail.
By the way, I think I did read that. I'm sorry. Yeah, I do see that.
No worries.
Hey, other trustees,
Yeah.
any questions?
I have a question. This is Erin Dalton from Allegheny County. Thank you for your presentation. If we could, I just want to go back to Exhibit E. So I think what you're saying, just as checking my understanding, is for the children's services, the CYS workers portion of the workforce, you're looking at you're looking at section E, part 10, and that's on page 10. Which I think, I mean, from my read, I'm not an attorney, but does seem like it can support positions and services because of the demand of opioid on the county and on the child welfare system. And then is it right that you would be looking at D on page 8, and hold on, let me just, sorry. Actually, page 9, number 7, right? Like, and you're suggesting that, or no, that's the treatment, that's the training. I'm sorry. Do you mind refreshing my memory on which parts of Exhibit E you think are most directly related? I think there is one in under the criminal justice involved populations that is less clear than the children and youth one. But I think you're suggesting your officers are providing some of that care where it can't be provided or not easily provided elsewhere. Anyway, do you mind refreshing my memory on where in Exhibit E?
No, not at all, ma'am. If we look at section 8 under D, arguably under number 1, supporting pre-arrest or pre-arraignment diversion and deflection strategies for persons with OUD and any co-occurring SUD MH conditions. And then we have examples. Also, number 3, support treatment and recovery courts that provide evidence-based options for persons with OUD and any co-occurring SUD MH conditions. Granted, we don't have a separate drug court, but we have the LEDI program, which is to bypass the courts, and that involves our probation department on a frequent basis.
Okay.
Then,
Yeah, and you're saying your officers are participating in those programs, and you're sort of subsidizing the time for them to participate.
so you could argue that number 6 on E9, supporting critical time interventions, particularly for individuals living with dual diagnosis, OUD and serious mental illnesses. Again, our probation department, somebody comes in, they have a problem, they want some help, even people that were formerly under formal probation or parole. Our probation department, they're the frontline workers, just like children and youth. They're the first contact people, and they end up trying to prevent further criminal activity, trying to prevent that there's any type of families broken apart. They're there to help. They serve the purpose as really social workers.
Sure. Thank you.
Okay. Any other questions from trustees? Does any trustee want to have an executive session to get any legal input? Or are we prepared to just have a discussion and a vote?
If I may, Mr. Chair, this is Commissioner Boozle. Obviously, these proceedings have opened up sort of our views as trustees and challenges our thinking in many ways. I would request that we step back from this. I have a suggestion, but I'd like to run it past legal before we proceed with it.
I think that's fair enough. I think many of us may feel that way, Kevin. So thank you. With that, we will have an executive session. It will not be more than 15 minutes. I now have 2:05, so we'll reconvene this public meeting at 2:20 and take a formal vote. So if okay. Thank you all I know we went a little bit over the 2:20 time that I said. I would like to remind everybody this is a continuation of the public meeting that was started at at 1:15. We did have an executive session. In between, we had various questions to ask of council as to whether things were permitted, not permitted, et cetera. And but we are now back at the public meeting, and I would ask any of the commissioners or any of the trustees, if you have anything that you want to raise as what points of discussion that we would consider as to whether to grant or deny the appeal. Kevin,
This
I'll
this
let
Commissioner
you,
Boozle, if I may, thank you.
I'll let you start, Kevin.
Thank you, Tom. I appreciate it. As you can tell, we've had a lot of deliberation over the course of reviewing all the programs, and yours is unique, and I think that we recognize that. I'd also like to say that at the advice of council, we've really we want to land on this in such a way because it does impact 67 counties, and we want to make sure we do it the right way. I think that there's some discussion about services and COS and probation that aren't quite clear, and we have to make those decisions. And I believe that the recommendation later will be that goes to a board vote. But to that point, I do appreciate each of the concerns that were raised here by you. By the commissioners, by your CYS director, probation director. I think that the full board, this DRC Dispute Resolutions Committee appreciates what you've brought to us. And I think you're going to hear some recommendations that I think would be favorable to you. So I'll let it go at that, Tom, and thank you.
You, others.
This is Erin from Allegheny County. I'll just reiterate a little bit of what I said, or you could tell from my questions. I do think Exhibit E is pretty clear as it pertains to children and youth workers. If we're going to ask you for some additional information, I would ask that you be as specific as possible on how probation is supported. Probation officers' activities are supported under Exhibit E. I know you provided some answer, but perhaps in writing there would be something more specific as to the actual services being provided. That seems to be to me the spirit of Exhibit E. Thank you.
Other questions? I'd like to also say, I do find this to be somewhat unique. Your county does not have the kind of many of the other services that some of the larger counties or many of the other counties have. And I do think that you're doing your best to address all of these, and I think that we should provide an opportunity for you to continue to find ways to help the people of the county. One of the problems that we have, and I struggle with, is although you're unique, size being one of those, whatever decisions we make is applicable to all the other counties. So that if we, for example, would authorize just using this to raise salaries to address your unique situation, there's no way we could turn to other counties and say, oh, you couldn't do that. At the same time, we understand what you're trying to accomplish. I understand what you're trying to accomplish, as I think my fellow trustees do. So that is the dilemma that we seem to be facing. But other trustees have other things that they'd like to add to that.
No, I think it's been well said. As a commissioner, we wear different hats, and the implication of making a decision that's going to affect 66 other counties together with Cameron and setting a precedent needs to be appreciated, I guess. And I always have a problem with saying, well, who's unique? Well, we all have certain uniqueness, obviously. And what is small? Mifflin County is a class 6 county, small class 6 county. I consider ourselves small, but yeah, you get it. It's very troubling when you have to make a decision based on uniqueness when I feel everybody is unique. And I also have a better appreciation for the CYS portion of this, but that's not the way it was broken out. So making a decision just on the CYS, I don't think we could do that.
Please.
I'm sorry, Edward, you were on mute, I think, for a minute.
Okay, with all due respect, perhaps this is the problem in the Commonwealth of Pennsylvania when we are always going to look and what's applicable to one county has to be applicable to all counties. We're not Philadelphia, we're not Mifflin County, we're not Allegheny County. None of those. What's wrong with this board looking at things on a case-by-case basis based on the proof given to you? We've submitted to you, I believe, a very cogent legal argument that within the spirit of Exhibit E, our caseworkers are performing these services. They're frontline. We don't have anybody else. I wish we did. I wish Cameron County flourished and had more services and availability, but we don't. So I'm not trying to lecture. Please don't take it that way. It's just that we hear this all the time. Like the commissioner from Mifflin County said, unfunded mandates. So figure it out, Cameron County. We are indeed unique. I'm sure other counties are, but we've brought to you what I consider a compelling case for you to look at our situation on a case-by-case basis and understand that uniqueness without worrying about it being a precedent, without worrying about what will the other 66 counties do. If they can come to you on a case-by-case basis and demonstrate that their services are not duplicative of other services, but indeed it is the primary service that can be rendered, well, then perhaps a decision allowing us to do this would be precedential. But again, with all due respect, I don't think you should be looking at this as, well, Cameron County is one of 67. We have to be consistent across the board.
Well, I will say that as being one of the people that helped negotiate this settlement and had 67 counties agreeing to buy in and do it, I do think the counties have to be treated, at least the same principles have to be applied to each county, although I understand what you're saying about the uniqueness. But I also think that to the extent that that we want to find a way to make this work, that we do need the entire board and not just the 7 of us as the dispute resolution committee. I don't want the 7 of us to speak for all 13. Okay. With that in mind, if we wanted to refer this back, delay the decision, if you will, not make the decision today. We do have a public meeting coming up on February 22nd. We do have working group meetings that are going to be in between. Would you, on behalf of Cameron County, consent to us referring this back to the entire board without resolving the matter today and without paying attention to our 60-day time limit for making a decision?
Yes, we would agree to that. In fact, I appreciate that this is not going to be a perfunctory determination, that this is definitely being considered. Thank you.
So you would consent to that if that's what the committee decided to do?
Yes.
Okay, I turn to the committee. You've heard that they would consent to this going back to the entire board. My view of the process would be for the working group that decided this to hear it out, ask any additional questions we want of Jessica. You seem to be the spokesperson or the person that's communicating this with us, that we would get any further questions answered. I'd like for you all to think of ways that you all can spend the money in such a way that you are aiding and addressing the opioid crisis, and perhaps use monies that you are otherwise spending out of other county funds and put it toward and put the opioid money toward those things and use that money to supplement the wages, if you will. Okay. Not saying that you have to. I just say please take a close look at that. But I, for one, would like to see a resolution made to the effect that the Dispute Resolution Committee, with the consent of Cameron County, is referring this back to the entire board for consideration of the record and the arguments that were raised by Cameron County in this meeting for further resolution, and defer this final decision on this appeal, and indeed on our decision as to whether or not the $22,842 was properly spent, and defer that to the February 22nd meeting of the full board. Could I have a motion to that effect?
I'll move that motion. This is Postal.
Okay. Could I have a second?
Second, this is Aaron.
Thank you, Aaron. Any discussion on the motion?
Can I just make one correction? The February meeting is on the 13th.
I'm sorry, the 13th. I will accept that amendment to the resolution. Great. Does council want to weigh in as to whether I'm completely out over my skis on this?
No, I fully appreciate the fact that this is a difficult decision to make. And I would agree, I've represented a lot of boards. This is a brand new process, and you've heard our side of things. You've heard about the uniqueness of Cameron County, and I do agree that the entire board should be involved in the ultimate decision-making. Thank you.
Okay, Jason or Jordan?
Possibility before making a final decision, so you're fine.
Okay. Okay, well, you have a motion. It's been seconded. We've had discussion. Any further discussion on the motion? Okay, all in favor, please say aye.
Aye. Aye.
Opposed? Okay, we will send this back to the full board. You've already heard what I believe the procedures will be, and we will go accordingly. I'd really like to thank all of the representatives from Cameron County. I know you're doing your best to spend this money in the proper way. We appreciate all the communications that you've had back and forth. We may still reach out to you for more clarifications, but we are trying to address this in a way that is both consistent with what we have to do as a opioid trust board, but recognize the problems that you're confronting and trying to make the proper use of the proper spending of this money. So thank you all very much for the presentation. And is there anything else to come before the meeting?
No, thank you very much for your attention.
Okay, you're certainly welcome. Okay, with that, the meeting is adjourned. Thank you very much.
Thank you.